the basics. In this section, I will be talking about contract classifications, statute of frauds, and statute of limitations, all of which you need to memorize to pass the state exam. Contract classifications. An express contract. The parties declare the terms and put their intentions in words, oral or written. Example, rental agreement. As a valid contract, a rental agreement must have the same components as a legally enforceable contract. Legally competent parties, mutual consent between the parties, a lawful objective, and sufficient consideration. The rental agreement is not only a contract, it's also a conveyance of a leasehold interest in real estate, which gives the renter a tenancy. Rental agreements between the property owner and the renter for 1 year or less can be verbal or in writing. Leases for longer than 1 year plus 1 day, must be in writing. However, all rental agreements should be in writing to clarify the duties and responsibilities of each party and reduce disagreements. Statute of frauds. Most contracts required by law to be in writing are under the statute of frauds. In California, the statute of frauds requires that certain contracts be in writing to prevent fraud in the sale of land or an interest in land. Included in this are offers, acceptances, loan assumptions, land contracts, deeds, escrows, and options to purchase. Trust deeds, promissory notes, and leases for more than 1 year also must be in writing to be enforceable. The principal agreements of interest in the real estate business are found in Civil Code 1624. Contracts that must be in writing. An agreement for the sale of real property must be in writing. An agreement that cannot be performed within a year from its making. This includes a lease for longer than 1 year. An agreement to employ an agent, broker, or other person to purchase, sell, or to lease real estate for longer than 1 year for compensation or a commission must be in writing. An agreement by a purchaser of real property to pay an indebtedness secured by a mortgage or deed of trust upon the property purchased, unless the purchaser's assumption of the indebtedness is provided for in the conveyance of the property. Statute of limitations. Under California law, any person filing a lawsuit must follow the time limits in the statute of limitations. The statute of limitations places a limit on the length of time a plaintiff has to file a lawsuit. Once the statute of limitations has expired, any lawsuit that could have been brought to enforce one's contractual rights is terminated just as completely as if they had not existed in the first place. There are time limits for filing civil actions. Within 90 days, civil actions to recover personal property such as suitcases, clothing, or jewelry alleged to have been left at a hotel or in an apartment must begin within 90 days after the owners depart from the personal property. Actions required within 6 months. An action against an officer to recover property seized in an official capacity, such as by a tax collector. Within 1 year. Libel or slander, injury or death caused by wrongful act, or loss to depositor against a bank for the payment of a forged check. Within 2 years. Action on a contract, not in writing. Action based on a policy of title insurance. Within 3 years. Action on a liability created by statute. Action for trespass on or injury to real property, such as encroachment. Action for relief on the grounds of fraud or mistake. Attachment. Within 4 years. Action on any written contract, includes most real estate contracts. within 10 years, action on a judgment or decree of any court in the United States. This is the end of topic 3, contracts, the basics.